Former Assistant State Attorney, Mr. Branning has extensive experience with the daily functions and procedures in county court. Additionally, Mr. Branning volunteers with the mock trial program for high school students, as well as the Harry Chapin Food Bank and the American Cancer Society. The legal system sometimes reminds me of one of my quotes that says, "The world is divided into people that think they're right." And this is the era where we sort it all out. Mr. Branning, the floor is yours. Thanks.
Mr. Ripper, I appreciate that, and good afternoon, everyone. What I'd like to do is ask the panel to introduce themselves briefly, so beginning with my right, Mr. Abbott.
Yes, my name is Colin Abbott. I am a managing attorney with Florida Rural Legal Services in the farm worker unit. Previous to that, I was a public defender here in Fort Myers, and before that, I had practiced immigration law for 18 years in Jacksonville, Florida, and handled criminal as well as immigration, as well as some civil practice.
Mr. Hall.
Good afternoon. My name is Cedric Hall, and I'm a private attorney. Previously, before becoming a private attorney, I was a assistant state attorney with the 20th Circuit.
Judge Hayward.
Hi, I'm Judge Archie Hayward. I was elected in 2010 to my first 6-year term. I was appointed previously to that in 2008 by the governor as a result of the applying to the Judicial Nominating Committee. I've been an attorney here in Fort Myers since 1984, having practiced in my own solo practice as well as with Florida Rural Legal Service as a staff attorney and a senior project group leader for their office, and I practiced with the Public Defender's Office for 5 years.
Finally, Mr. Justin.
I'm Larry Justin. I'm an assistant state attorney. I'm the county court division chief here in Lee County. I began my career in 1980 with the state attorney's office, did 9 years, was then 2 years as city attorney at Fort Myers, then went into private practice for another dozen years with the law firm Peter Ringsmooth, and returned in 2003 to the state attorney's office, where I now supervise beginning attorneys as they leave law school and teach them about the county court and put them into court and keep it going.
Thank you, sir. I'd like to thank all my distinguished panel members for joining me here this afternoon with what I expect to be a very informative discussion. Briefly, I want to just reiterate the purpose of today's symposium. That is to demystify the county court process, both with the types and nature of the cases involved that often come through the county court arena, and then get everyone's input on how their individual field affects that, and hopefully provide the public with a greater degree of understanding of the county court process. I'll begin with Mr. Abbott and ask, I apologize, how Florida Rural Legal Services, the interaction you have with the county court system.
Florida Rural Legal Services is a non-profit law firm who is located all throughout Florida, and we get government funding, both federally and state funding, to help people to meet certain legal criteria, and those criteria include their legal status as well as their financial abilities. And once anyone who needs help concerning civil matters, because we're not allowed through law to handle criminal cases, that goes to the public defender's office, we do an intake, and at intake we decide which way, which method, and which direction individuals need to go. Some individuals we refer out to private attorneys, and in those cases there's usually a bar association that can listen and try to help individuals. We also work with private bar members to try to get individuals who sort of meet the financial burden but may not qualify for us for other reasons, as well as we try to provide educational services to individuals who may decide at the end of it to go what is known as pro se. And pro se is where you go yourself and represent yourself in court. Today we're specifically talking about county court. And the old expression is that county court is the people's court. It's the court where people can present themselves, and the best way, or one of the unique ways that county court exists, is what's known as small claims court. And I'm going to spend a few minutes sort of going through the small claims process. I'm not going to go into it in detail because there's books written about that, and there's a whole set of civil rules written about that. But basically, the county court is divided into a small claims court, which involves issues, financial issues up to $5,000. Between $5,000 and up to $15,000, it usually goes to county court through regular court filing process. In the small claims court, there exist rules that are unique to small claims court, and county judges such as Judge Hayward sit on the small claims court bench as well as on the county court bench. And at that stage, it's more of a non-logistic type of court in the sense that people usually present themselves. There is forms that can be used whereby you can fill in the blanks to present your case, and again, you have to present a legal case. And I stress this to all the people that I meet with during outreach or I meet with who come into my office, is that it is still a court. You should still use decorum. You should still be respectful to your opposing party. You still need to be respectful to the court officials, to the clerks, to the judges. There has to be a legal grounds for such a charge or a claim. It's called, in small claims court, it's called a statement of claim. And that derives from the old British tradition of there being an actual claim itself, equity claim, but I'm not going to go into that. There is filing fees, like with any other administrative or court process. I contacted our court here in Lee County today to confirm that no longer is there a waiver available for these fees. There's fees that are designated based upon the amount of your claim. But the court clerk stated to me that they do now have a payment plan in place, and that costs $25 more. And so people that don't have a lot of money, they need help, can go make their own small claim action. And the clerks are excellent in Lee County, and I've worked all throughout the 20th Circuit. They're excellent in all the circuits to help. That's one thing that we should be proud of in our circuit, and all our counties, is that the people that work within the government are there to help the individuals. And that's a goal I always have, working in public service with legal aid, with Florida Rural Legal Services, is that they need help, and we're there to help them. We don't make money off of this. This is to help the people. To continue, the small claim process itself is documented within the rules, and these rules are governed by the small claim rules that are available at your libraries, on the internet. Most court clerk offices have copies of those rules. They're available at the Florida Bar for free. So I encourage people that are going to go to small claims court or attempt or want to go there to go and look at these rules first to see if they do have a claim. I don't have enough time to go into the exact contents of types of claims. There are different types of claims, and there's different types of forms that are available based upon those claims. But again, I just want to indicate that we have a process in place where people that have civil wrongs, and that's non-criminal wrongs, can go to a public court, have their issues dealt with by a sitting judge, and come to some resolution.
Excellent, Mr. Abbott. Thank you. I'll now turn to Judge Hayward. And since we've dealt specifically with the civil end of the spectrum, I'll ask Judge Hayward to comment kind of as a broad overview of what county court does in broad strokes.
The county court handles both civil and county court issues, and civil and criminal matters. The criminal matters are generally misdemeanors subject to a penalty of up to a year in the county jail. Anything less than that can also be considered such as a second-degree misdemeanor or other county court ordinances or municipal ordinances. In the civil area, as was stated, we handle the small claim court matters up to $5,000, county civil up to $15,000. Anything above $15,000 goes into the circuit court for civil matters. And anything punishable by over a year in the prison system can be considered as a felony charge. In the county court, we also handle traffic cases as well as domestic violence docket. We also handle the first appearances as the county court judges. We also take care of first appearance matters. And these, the matters that we handle are generally either represented by counsel, or we have, as was stated before, pro se parties. They can either be the plaintiffs in the civil matters, and in the criminal defense matters, the pro se litigants will be those people who have been accused of a crime but have opted to represent themselves. So we handle quite a few matters in different areas of the law that come before the county court.
What kind of percentage, Your Honor, do you see people actually go with the pro se defense? Do you think most people have an attorney or seek the services of a public defender?
But the majority of the people have representation. However, I would imagine anywhere from maybe 2 to 10% of the people are not represented, and some of them because there are instances where a person may need a driver's license. They have a charge of driving while license is suspended or no driver's license, and they know that they're going to be able to obtain a driver's license, so therefore they would not opt to have an attorney because they know how to resolve their matter. And we also have some citations that are given by wildlife officers for fishing without a license or fishing out of season, or taking those cases generally are going to be able to be resolved without representation. However, some of those opt for attorney representation because when you're charged with such a license violation or a wildlife violation, that could mean certain, there are more ramifications than just the criminal aspect, can lead into civil matters where the property is taken.
For the benefit of anyone watching, is there a mechanism in place where the court could decide or ask an attorney to sit with a pro se defendant just to advise them about legal terms and the rules of evidence, things that your average person simply might not know?
There is a specific process that the court must consider when allowing a person to represent themselves, especially in a criminal matter. It's very important for that person to have an understanding of the rules of criminal procedure as well as the evidential rules that come into play. And if for some reason the person wishes to represent themselves and they feel competent, and the court goes through the process of determining that they have sufficient enough information or knowledge about how to represent themselves, but the court has some concern about the need for more in-depth knowledge, then they can appoint counsel to sit with the person and act as a resource for the person. And a lot of times the public defender attorneys are asked to sit in that position and provide that knowledge and resource.
Very good. Mr. Hall, I'll turn to you. Having worked both as an assistant state attorney and now being in private practice, give us a broad overview or a brief description, if you would, of how a criminal case might come to be in county court.
Well, first the person gets arrested. Of course, there are two ways that a person can have an open case in court. One is being arrested. The other is what we call an open booking sheet, where they will be picked up on a warrant. Sometimes a person could get arrested and spend some time in jail, or sometimes a person can receive a notice to appear, which is a little citation or a little piece of paper saying you have to appear in court on a certain date. Those are the first areas on how a person can actually, or how a criminal case is initiated.
From there, do they go to the first appearance that Judge Hayward just mentioned?
Well, if they're arrested and they haven't received their bond yet, yes, they will go before a judge within 24 hours, commonly known as first appearance. Some people call it 24, but it's first appearance, where a person will go before a judge and either receive a bond or don't receive a bond, but they'll receive the next court date. Okay.
And if a person is given a bond, I mean, if they're allowed back out on whatever the bond is, they're then given their next court appearance?
Yes.
And yes. In between the first appearance and that next court date, what role would you take?
Well, even before that, I've had on occasion where a client would call me, or his family members would call me, to actually appear at the first appearance.
Okay.
If I don't appear and they happen to get out on bond, and then they'll come to my office and seek advice on whether they should get an attorney. Does the charges warrant it? At that time, I would instruct them about their rights, their right to remain silent. We mentioned earlier in federal court where a lot of clients get on the phone and they start talking. I give them a kindly reminder that everything they say can and will be used against them. A lot of times it's a little bit too late. So,
but when they communicate with you, initially doesn't the attorney-client privilege come into play?
Yes, it does.
Okay.
Everything that we talk about in that meeting is confidential.
Good.
And it's important to the clients that you say that also, so they can be truthful in it up front with you.
Okay. So while you're meeting with the client and possibly their family regarding retaining your services, from your memory of being with the prosecutor's office, what's happening at the state attorney's office simultaneously while this is going on?
Well, while this is going on, the paperwork is being forwarded to the state attorney. And I know Larry can attest to it, that it goes from the clerk's office to the state attorney's office. And there is actually an attorney that actually, in the county system, there are 8 judges. And every judge has a certain week. Some judges are in trial week, some judges are in first appearance week, where they would actually receive cases. Every judge has a state attorney, and I might be treading on Larry Waters over there, but every attorney has a state attorney that's assigned to them. While this case is going through this process, that attorney is in another part of their week. When they're in their intake week, that's when they can actually make a decision on those cases.
Okay.
Me as a private attorney, I do have an opportunity to talk to the state attorney and say, okay, I do have some extra information that you might not be privy to right now. So I can call, or defense attorneys can call the state attorney and actually give them another insight before they make the decision on filing the case.
Okay. And if they do decide to file that case, that's where we have what's called an information?
That's correct. It can be either through an information, or sometimes if it's a traffic ticket, the traffic ticket can serve as an information also.
Okay. So once they've got that document, that tells them the charges that they're facing.
Yes.
Okay. And you get a copy of that as their attorney.
That's correct.
Along with the evidence that has been provided by law enforcement.
Yes, and we commonly call it as discovery.
Okay.
It's just all the papers that the state has against the client.
Okay. I will now turn to Mr. Justum. Mr. Justum, at this initial phase that Mr. Hall's referenced, how does the Office of the State Attorney at the county court level decide, when you get the information from law enforcement, how it goes to which judge or which prosecutor, How is that determined in the state attorney's office?
The decision as to who the case is assigned to actually comes through court administration. They assign the judges. It's on a rotation basis. Whoever is the judge assigned that week that you get charged with a crime, that's your judge throughout the case from start to finish.
Okay, so it's a random, non-specific.
Yeah, whenever you choose to violate the law, that depends on what judge you're going to get. So if you're going to be selective on what crime you're going to break or do, you pick your judge.
Allegedly violate the law.
Well, yeah, I'm biased. Mine says state attorney's office, but it's a system set up by when the violation occurs. And it's important to know that the county court is probably the court that most people, even from my point of view being a prosecutor, that most people are likely to attend at some point in their life. And you have to remember that when you're talking about crimes, it can be, if your sprinkler, I saw on the news we're going into some water shortages, if your sprinkler timer doesn't go off at the right time and code enforcement knocks on your door and you're the unfortunate person that had to answer the door that time, you're going to get the ticket and you're going to end up in county court because that's a county court violation. And the state attorney's office is charged with even prosecuting those kind of cases. And it's what we strive for at that point in time as the case is coming in is to common sense. And it's not a black and white area of the law. I encourage the new attorneys to use common sense because if the code enforcement person is knocking on your door and your wife is closer to the door, she's going to get the ticket. And if it's your job to reset the timer, the code officer might not want to listen to that very much. That all I did was answer the door, why am I getting the ticket? And technically, why am I being charged with a crime? So we try to bring common sense to a lot of the offenses that come into county court because it's important to remember county court is very unique. It is the only court that you can be charged with a crime that doesn't come through the state attorney's office. Code enforcement officers are allowed to give you the ticket, which is the charging document, and then you are already charged with a crime. It's not like in the federal system where they take it to a grand jury or the U.S. attorney gets to review it. Law enforcement officers in the state of Florida are authorized to issue criminal traffic offenses or criminal traffic citations, the ticket that you get if you're stopped for a traffic offense. The legislature's made some of those civil traffic offenses. They come in front of Judge Hayward and his colleagues. We don't have jurisdiction over those. But a little bit more egregious offense on the roads.
No, I'm sorry to interrupt. Are you talking about like speeding tickets and tag
careless
violations?
Driving, tag violation, things that are common every day. You back up careless driving, you hit somebody. Those are civil traffic offenses. They will get you into court in the county court system. Criminal court, a little bit more egregious charges, a little bit more serious. The legislature has designated those to be reviewed by the state attorney's office, but they can actually be charged by the law enforcement officer on the road that issues the citation. That's the charging document. What we do between the time that document, that charge is brought pre-date of incident to the arraignment date, we have about 3 weeks. And we actually, each judge, as it's coming into our office, we have 1 week to basically produce all the documents for that court's arraignment. And I checked this morning, last week we had 500 cases to deal with and get processed and paperwork done and reviewed by the one attorney, and in 1 week to get it done. And that's basically from Monday till mid-afternoon on Thursday is the goal, because then we have to get all those cases to the clerk's office. They have to process them so that they're ready for the judge on Monday. So
well, you raise an interesting point that I was going to touch on. What kind of time span, how many assistant state attorneys are we talking about? I understand that you're in charge of the entire circuit, but in Lee County, how many ASAs do you have working in county court?
Okay, there's probably some other attorneys around that probably flinched right now. I'm not in charge of the entire circuit. I don't want to be responsible for the entire circuit. I'll take Lee County, which is the biggest county. That's enough. In our county court division, we have 8 attorneys right now. Okay. We had 9. 1 has just moved into felony, and I don't think we're going to be able to replace that attorney now because of the budget concerns that we're having. So we're now 1 attorney shy in the county court division. We have 8 attorneys, and just as an aside, I read up on this. We're supposed to bring this to the common sense, common language, and not all the legal verbiage. I saw in the news press there was a comment, and you get some of these comments sometimes. They were on both sides, but one was, "Way to go, Mr. Thomas! Bring this information to the people." And then somebody wrote in and said, "Well, who's paying their salary? Shouldn't they be working?" I just want to make it clear that the standard that I apply to the attorneys is you will get the job done. If you had time to sleep, then you had time to get your job done. We're salaried employees, and we work until the job is done, and we do make every effort so that when Judge Hayward takes the bench on Monday morning for arraignments, we've processed every piece of paper that's come through the office. We have that clock is ticking the whole time. We have very limited time to review these cases, to put them together, and make a reasoned decision as to whether or not this is a case that needs to go into the court system, whether it needs to go into one of our diversion programs that we have created since Mr. Russell became the state attorney. Those are for cases that, black and white, they are a violation of the law, but they do not rise to the level that we need to prosecute people and expose them to the risk of, up to a year in the county jail. We divert them out of the system, put them into programs where people learn not to mess up and move on. But that decision is made very fast in a very high pressure type situation.
So I think you said earlier, to have those 500 cases, that is 1 week's worth of arrests. Is that accurate?
Yeah, arrests, citations, and charges.
Okay.
And then the next week there'll be another 500 or 500 to 600.
Then my follow-up will be to Judge Hayward. Your Honor, if you know, let's say the last year of 2010, 2009, do you have any idea how many cases actually came through the county court system so that the people at home have an idea of the volume you're dealing with?
Oh gosh, I can't give you a number. It's, when we see the case numbers, you can have an indication of how many cases have come through, and it doesn't even say how many charges, because one case can have multiple charges.
Sure.
And so if we're doing 500 a week, and
right, I mean it's going to be exponential. I understand.
Yes,
yeah,
and again, that's just those cases, and it can be individual. So I can't even guess.
I understand,
because it's quite an enormous amount of cases that run through. But it's so funny when you look back and you look at at some point in time, you started out, the case numbers were 027 or 77, and then they end up being like 5,000, however many. And it's like those many cases have gone through the system. And just on your docket alone, you're amazed how many cases we do handle.
Right, and as Mr. Hall pointed out, you're just one of 8.
Yes. So
that's easy multiplication. If you've gotten to 5,000, you're talking about 45,000 cases every year. That's an impressive number. Mr. Hall, having heard those numbers, what do you see as ways to improve efficiency in the county court? Or let me back up. Have you seen technology and things like that continue to help the court system move more fluidly? And what would you see happening in the near future?
Well, I think one program that really helps the system is the state attorney diversion program. It in fact takes some of the participants away from the actual making appearance in court, so you can actually see those cases that are more egregious, so to speak. I think that helps out a lot, and I think we need to lobby more to the legislative branch to receive more funding, or to receive our due funding, let me say that, in order for us to keep up with the current pace of the activity that occurs to make these cases appear. I think that's the biggest plus that I can think of right off the top of my head.
If I could add just briefly one thing that Cedric's not aware of, and I'm not sure many people are. Last week, in an effort to speed these things up, we began doing all of our intake and the processing of all these 500 cases electronically. We do them now digitally. And we went to an entirely paperless system. We quit killing the trees. I mean, we were killing, you imagine how many pieces of paper that was.
I remember.
And last week was our first week of doing it. We processed all 500 cases electronically, digitally. Went into the courtroom in front of Judge Adams. We had a clerical person in there working on the computers, and we had people standing around in case the computer system crashed, and we were left with nothing because, trust me, an attorney's security blanket is to have a file in their hand and paper. And we did the entire 500 case arraignments through Monday, Tuesday, and our in-custodies on Wednesday digitally without paper. And we've saved costs. And that's everything nowadays, is doing justice without the money. And I don't foresee the legislature helping us any, but we were able to do that. We're moving into it. And now every week we're going to be doing electronic intake and electronic processing of the files. The attorneys are set up. They're going to be able to work from their homes and access our systems through the computer programs. And they will spend the time the weekend. They have their own printer now to print from. And we've taken a great deal of advancement along those lines, and we just put that into place, and we're actually, the legislature is just now talking about mandating that at some point in time. We're ahead of them, because that's our goal, is to stay ahead of this, because it's not going to get better for a while.
I can understand that, and that I'm sure helps with your philosophy of them working nights, weekends, and holidays. Your Honor, what do you see, since Mr. Justin brought up a good point, you've got, and I think we heard in some earlier discussions about cell phones, from a perspective of a jurist, how do you see the advancing technology working with defendants or attorneys that come before you? Like, someone's phone now can do almost anything you can do in the office. And I'm sure you've got attorneys who bring in laptops and iPads or what have you. Do you see that assisting kind of in the fluidity of the case management? Oh,
yes. I think that the modern technology that we have at our disposal helps us a lot. In our criminal docket, the courts are already using computers in the county courts. And since I'm one of the newest county court judges, or not the newest, but one of the newest, I've never used the paper files in the criminal docket unless the computer is not up, or we start earlier than the clerk provides assistance for. Then we use paper. But other than that, I've always used the computer. In our civil docket, we have the files, and we still use them. But the clerk, I believe, is under a mandate as well to switch over the civil docket to the computer, and so therefore we won't be able to rely on the paper files. The attorneys are now being able to file electronically. I believe they just started that, what, about 2 weeks ago? Or
it was recent.
It was very recent. So that will probably lead into using of other electronics. And in our Charlotte County office, they have nice little screens for each juror in the jury panel. We have not obtained that,
gotten there yet.
that technology development in the Lee County courts yet. But we do have modern courts now where our projectors and equipment comes from the ceiling, and that allows us to provide, to utilize the computers and laptops, and they can put in disk and put that information up on the wall for the jurors to utilize. Sure. Now, the one interesting thing that came about with all this technology is they've just created a new jury instruction on the use or the prohibition of use of technical devices for jurors. And during the course of the trial, of course, you can retain your telephone or cell phone or your PDA, whatever device you have, but during the deliberation of the jury verdict, none of that is allowed to go into the courtroom, into the jury room for deliberations, and neither can you tweet or Facebook about what your activities are on the jury panel in that case, because that is prohibited.
You raised an interesting point. I'll direct this to Mr. Hall. Mr. Abbott, I've got a follow-up for you. Mr. Hall, as a defense attorney, as a trial defense attorney, are you concerned about the way that, again, let's just use the average, we'll call it a smartphone for lack of a better word, are you concerned that when you're doing a trial and you've got a defendant, that someone on your jury might be looking something up on their phone and getting extra information that isn't coming from the witness stand? I mean, is that a concern for you these days?
It can be a concern. Excuse me. I think it is a concern because a person can actually get on newspress.com, if we're thinking locally, and actually read up on a certain case. And that could taint their decision. They do receive instructions by the judge stating that they shouldn't talk to one another. And I believe, and hopefully down the road, we'll be able to add in those instructions, please do not read any media incoming off your PDA or whatever. And I believe that's already in there, but it's not electronically yet. Am I right, Judge?
There are new instructions, I believe, address that issue.
And I believe that was in the Bar News just recently. They published those. One thing that I think that actually helps the system is, and Lee County is pretty good about it, is allowing the attorneys to actually read the booking sheet or read the files for court. So to answer your question earlier, that helps speed up the process also. I wanted to add that along with that question.
Mr. Abbott, what do you see as the advent of technology from a small claims or a Florida Legal Services perspective? What are you finding that's being a benefit to you and your clients?
I think the technology is like any other tool that can be used to benefit and to endanger or make things more difficult. For example, in a small claims action, we could use technology to make sure that we file against the correct party. And when I mean file is that on the small claims sheet you put in the correct name. So you can go to the Sunbiz homepage, which is a Florida corporate, and you can search to find who the executive director or the directors of companies are. If fictitious companies exist, people are doing business as other people or other entities. And that way you can have the correct name in your statement of claim that you file in small claims court. Also, examples that we use, my office and the attorneys that I work with, we do a lot of wage claims. And in those cases, oftentimes we have middle contractors that we don't know where they are, who they are, where they work. We can search under the Florida business section to see where their licenses are. We also can find, by using the mapping services available online, to find out where a certain location was that a worker who may not even know this region was working. And from that, then we can do property searches in the county property. Each one has county records, each county, and you can find out who the owner of a business is, who the owner of the property is, how much land they own. On the negative side, oftentimes the media and different other technology can prevent individuals from getting fairness, in the sense that there may be two individuals that are in civil court and one person has more economic, political, social power or strength or abilities, and they can utilize the media or the savviness they have. And in those cases, technology can be negative. Again, that's where we go to the Constitution, the Florida Constitution, the Federal Constitution, the rules of court, the judicial discretion, judges like Judge Hayward who sit impartially and listen to both sides. We go to working with the state attorney's office with opposing counsel to make sure that civility exists. And technology, I do a lot of federal court cases because of a lot of the claims I have are in federal court as well as in state court. And there's a number of federal courts now that are 100% technology driven. Recently I was in a court in Georgia. Everything was on computers. The judge had a computer, each lawyer had a computer, every document we presented was on computer. That may be the direction we go to in the future. Again, that has its drawbacks because computers can go down. Paper disks can be erased. Hurricanes can come through and destroy. And then that's our duty as court officers, as attorneys, as litigators, to make sure that there's backups. But again, to cut your question short, technology is great if you use it correctly. If not used correctly, it can be just as bad as anything else.
One other thing I wanted to add is that now the discovery process is even more, that much greater, because some items can be discovered through looking at a web page, Facebook, MySpace. So that can actually either help or hurt your client. So that's another avenue. I think the federal rules of evidence and the Florida rules of evidence have to actually catch up to that, to our technology, to actually maybe allow some of that or discredit some of it.
Okay. Well, I'll post this question to both Mr. Hall and Mr. Justin. We understand that when law enforcement makes an arrest, the state attorney's office makes a filing decision, defense attorney gets involved and begins speaking with the prosecution. As the case progresses over the weeks and potentially months, from each of your perspectives, what are you trying to do in accomplishing your specific goals? What steps are you taking? I'll direct first Mr. Hall. What steps do you take as the case goes forward in your discussions with the prosecutor? What are you doing most typically with your clients that brings the case to either some kind of resolution, I'm assuming either through trial or a plea?
Well, each case is different. Some cases you might be looking for a witness, but you're ultimately looking for justice for your client.
Okay.
To make it short.
Mr. Justin, what are your assistant state attorneys charged with? What are the responsibilities as the case goes forward?
The theoretical and philosophical approaches, we're charged with the responsibility of doing justice. That's the textbook answer to that question. But the bottom line is we're trying to resolve the case in a manner that is appropriate for the nature of the charge. And if you remember that this court is the court that most people are likely to end up in if they're ever going to end up in a courtroom, and you take into account that good people can do bad things, you just try to have a feel for what is the appropriate sanction for what the act was. And we analyze the cases and we tender those offers to the defense, and if they are willing to accept the offer and the court feels it's within the parameters of what they can accept, the case is pled and sentenced and the person moves on and we all move on. If there's a disagreement about what the appropriate sanction is or the culpability of the person, then we have trials.
Okay.
That's the end result, would be a trial in front of a jury to have the jury determine whether or not the person has violated the law.
In doing so, and I think you touched on this when you discussed your diversion cases, do the assistant state attorneys look at someone's background or lack of background in making those determinations? We
look at all the factors of the case, person's background, their history, the circumstances of the case. It is against the law in the state of Florida, as an example, to drive with a suspended driver's license. And I had a prosecutor come to me once and they was very upset because the sentence actually called for the person to be charged with a felony case, which is much more serious, and the charge meant if they were found guilty, it required a prison sentence for driving on a suspended driver's license. And based on my experience, I know that there's lots of different reasons, and I tell my attorneys to look at the background. A person can be driving on a suspended driver's license because they have to go to work. If they're not going to work and there's no bus system, and I take that into account, can we impose a penalty? The person that they were upset about, they came back to me later, they had actually been arrested for driving on a suspended driver's license during a drive-by shooting. So they had no qualms about sending that person to prison. They were the driver of the car, and the person was hanging out the passenger seat shooting. But I do look into the facts and circumstances. A petty theft is a petty theft, and we deal with a lot of those. Is the person stealing from a local establishment to fund their drug habit, or did they go and steal to feed their family? It's both a crime. But we, in my position, I get to be the gatekeeper, and I do get to propose penalties and even determine if that case should go to diversion or not. We get the position of being able to put a human touch on the court system and take into account the actual human factors behind that. And it can be a great burden, but it's what the job entails and requires, is a human touch to the charges. Background, circumstance of the offense, likelihood to repeat a crime. Is this something we really need to put into the court system?
Well, Judge Hayward, I'll follow up with a question of that. How involved, if at all, are judges in the plea negotiation process between the state attorney's office and the defense bar with, like, Mr. Hall?
Okay. Basically, the judges are reluctant to be pulled into the negotiations of a plea bargaining. And I say that in this way: the judges should not be involved in negotiation of plea bargains, because that's between the state and the party. Even in the civil situation, that's between the parties, and in a civil situation there's preliminary hearings and both parties can mediate. In a criminal situation, if the state attorney has an offer, the court is obligated to make sure an offer is conveyed to the party. The party then can decide whether or not they want to accept that. But there are reasons why the judge would not get involved in that negotiation process, because if the judge is involved in the negotiation process and for some reason the person decides not to accept that offer, then the judge is at some point hamstringed into honoring that offer or not sentencing above that offer. So in order for the judge not to become biased or promise something to encourage a plea, then the judge has to stay impartial and not involved in the negotiations. The judge can say whether or not they will accept an offer that's been negotiated by both parties. The judge always has that right to decline or to accept an offer, but the judge should really not be involved in the negotiations.
Okay, good to know. Well, ladies and gentlemen, we've got about 10 more minutes. I wanted to open the floor up to any questions that anybody in the audience might have about the county court system or any of the roles that our distinguished panel has in that system. Yes, sir.
I'm Norm Jennings from Cape Coral.
Good afternoon, sir.
And what I would like to know is how are they going with all the advancements in technology and everything? How is that going to affect a person going pro se and being able to get information? And it seems like a lot of that information is restricted only to attorneys, and you have to pay a fee for it. In some communities, I mean, you have to pay a fee for it in order to get it from the county even. And the other thing I was wondering about is if a person is charged with a felony or something of that nature by an indictment or by information, can he request an indictment instead of information?
Okay. Let me deal with your first question. It was regarding public access to what may be typically attorney information. Mr. Hall, do you want to take that, if it's a pro se defendant?
Sure. There are a couple of avenues that pro se could take with technology. He or she could go on the Lee Clerk site and actually look up his or her case. Attorneys also has that capability also. In fact, we have to pay also a yearly fee. In the past, it was free, but due to the financial situation that we're in now, we're now paying. I would say that it helps a pro se defendant. There are other alternatives also that pro se defendant can actually come in on the second floor of the courthouse and actually inquire about their case also. There is a law library also downstairs right beneath the elevator or the escalators, and they can use those resources. Those are free also. They also have access to LexisNexis, and maybe I shouldn't be giving this much information because that means they won't hire me, but there is a lot of technology out there to help pro se defendants. Criminal.
And on the civil side, there's a local bar associations that have what's known as pro bono attorneys and pro bono assistants, and most associations in almost every county in Florida have different free clinics.
I see.
Like, for example, our office down here in Cleveland have clinics on foreclosure. So there people can come in, individuals, and meet and talk to attorneys for a few minutes or whatever is needed. If they want help, they get help. If they want to have access, you know, we can provide as much representation or as assistance as needed. Also, the Florida Bar has a 1-800 number that you can contact to get legal advice. You can contact the bar associations for specific topics. If you look up online, there, you know, if you have an immigration issue, there's AILA, American Immigration Association. There's bankruptcy assistance. Depending on your legal needs, there is agencies out there that can help with civil matters. Also, a lot of the issues you may have may simply come down to needing to talk directly with a government agency, a government official, and oftentimes if you have an issue with officials or representation that they're providing you, they have mechanisms of ombudsman. They have other types of ways that you can utilize the internal administrative functions without having to go to the court system at all. And you know, so it's pretty much, there is means and ways out there. But again, it's difficult. As a pro se litigant, which is a person going to court on their own, it's never easy. And what I found is that court clerks, court judges, such as Judge Hayward, they have a capacity to provide that assistance because people are there to get help. And they're there to provide help and provide resolution or provide needs. And you know, you've got to have the faith that the government is there to help. So.
Okay.
Can I add just one thing, real quickly? I know of no other profession. There's an adage that I tell people, because they walk into my office a lot and I get asked that question. There's an adage that says, you know, law enforcement officers, cops, and lawyers are two people you never want to see unless you need them. People walk into my office all the time asking me, how do I do this, how do I do that? And my response is, in a nice sort of way, I don't know very much about my engine on my car, and if I pull out my wrench and start trying to tear it apart, I'm going to do more damage. But there are a lot of people out there that do that for a living. I know of no other profession other than lawyers that in order to practice law, you have to give away free services. All attorneys are bound by our Florida Bar to provide free service. And it's the pro bono that was mentioned earlier. And I know of no other profession in order to practice law, or to practice that profession, you have to give away your services. So there are plenty of lawyers out there, there's plenty of services, as Mr. Abbott said, that do provide assistance to the general community. And that is one of the positive sides of our Florida Bar. I say that facetiously, but we do are mandated to give away our services. As a state employee, I can't do that. But there are ways that the bar and members of the law and profession do assist the citizens who can't afford to pay for an attorney.
Just for those people watching at home, the phone number for the Lee County Bar Association is 239-334-0047. That's 334-0047. Mr. Justin, I'll ask you to follow up with part 2 of this gentleman's question regarding would someone ever get a copy of their information or their indictment?
The copy of the information and indictment, that can all be provided by the clerk's office. One of the things that, again, I get these questions a lot from people walking in the office. We are bound in the state attorney's office to follow the rules of criminal procedure. And there are ways within the rules of criminal procedure to obtain those documents. I always, when somebody's asking me that question, and I know they're the other side, I says, you have to remember, I'm the other side. I can't tell you how to do it any more than I can tell you which wrench to get to change the spark plug in your engine, because if you misset the gap, you're going to mess something up. But there are books that will tell you how. If you choose to do it yourself, go to the law library and the other methods that were spoken of. But there is a way to do it. It's in the rules. And with the day of computer, you can pull it up, and people do, and they file the appropriate documents. It's not to say that I haven't gone in and hit print on the computer and walked in and handed them a copy of it, you know, but we're not obligated to. I really shouldn't be doing that. But there's methods, but it's not an easy system any more than tearing your engine apart.
Well, the other question I was wondering on that same line, though, is also if you're charged with a information, can you convert that to can you request an indictment?
No. If someone's charged with an information, can you request an indictment instead of an information?
Instead of the information?
No.
Instead of being charged by information?
Yeah, they're going to be both charging documents.
Yeah, right.
In the county court division and in all the criminal courts in the state of Florida, the only charge that has to be by law and taken in front of a grand jury is capital murder, first-degree murder. Short of that, everything can be charged by information. The sole discretion on whether to charge or not charge is given to the state attorney.
I see. Okay. Thank you.
All right, gentlemen, I do appreciate your time today. That's, I think, our time. I'll thank my distinguished panel members for joining us here today. Mr. Ripp.
All right, on behalf of Citizens for a Better Fort Myers Government, we want to thank our moderator and our distinguished panel. We hope the public has learned a great deal about our legal system today, and we'd also like to thank our financial supporters with whose help we were able to put this program together, including Christine Matthews, Bail Bonds, Earl Smith, President of Bill Smith Appliances, and Steve Phillips, CPA. Thank you very much. Have a great day.